Are we done here?
No, you don't understand, ma'am. You don't understand.
Are we done here? Are we done here?
Perjury
Here?
is
Do not insult my intelligence.
You have to
do not insult my intelligence.
You have to lay your
Please do
you
not
have to
insult my
lay
intelligence.
your it's a false statement made on
Are we done here? Are we done here? Yes,
that is not what I said.
I said
that no, I didn't. You
yes,
said
you
that.
did. You stated
I said that circuit.
You stated that the criminal. You stated that.
I never said that.
You won't believe this. $10,000 for a bad date? A woman sued a guy she went on one date with for emotional distress. $10,000. Here's the thing. Emotional distress needs proof of serious, intentional misconduct, not awkward vibes, not a bad night out. She acts like this is a landmark case. Judge Boyd stays calm, analyzing, not entertaining. Courtrooms don't reward loudness, they reward evidence. What do you think? Should courts be stricter on cases like this? Drop your thoughts below and hit like if you thought this was wild.
Quashante Short, QASHONTAESHORT. I'm sorry, I had to.
In the background.
I'm actually at the airport, so I had to go outside. It looks like they just departed a flight. They just arrived a flight. So I'm outside. It's a lot of people. It's a lot of people around. So I'm trying to go where there's no traffic. But thank you. That's okay. That's okay. No, I'm trying to finish this before I get finished. It's actually louder in here.
I'm not sure. I read your complaint again, and you have not. I'm looking here. What is it? Intentional infliction of emotional distress?
Yes.
Is that the claim?
Yes, it is.
That's not something that's really justiciable in district court.
I'm sorry. I can't hear you.
I said that's not something that's justiciable in district court. That has to be brought in circuit court.
So you said it's not permissible in district court. It has to be taken to circuit court?
That's an equitable action, yes. Mm-hmm.
Okay, was that not I thought only criminal offenses, I guess it would be considered, I don't know if it's criminal or however you want to consider it, but I thought only criminal offenses were brought before the circuit court. So will I have to,
what's in your head. I cannot get into what's in your head, man.
I'm sorry, I gotta go back in because I can't hear you.
Mr. Jordan, let me just ask you this. Are you planning to represent yourself on this?
To be honest with you, sir, I thought this was just going to be thrown out. We had a date, one date, and nothing else after that. And now I'm being sued for $10,000. I don't see how this is going to go any further. I think it's a waste of your time.
The problem is this, if you think it should be dismissed, you need to file the appropriate motion. You need to file a motion to ask for that.
I will do that. I really didn't know what to expect. This is all new to me. I've never been sued before. I've never, gotten in any trouble. This was just, I don't know. But if that's the process I have to take, then that's what
Imagine going out to dinner and ending up in a lawsuit. That's this guy's reality right now. Now, to be fair, intentional infliction of emotional distress is a real legal claim, but it has a high bar. The conduct must be extreme and outrageous, not he didn't call back, not the date was awkward. The defendant looks stunned, like he blinked and suddenly owes 5 figures. Meanwhile, she's presenting this like she's arguing a Supreme Court appeal. The tone difference in that courtroom? Wild.
There was also a perjury on there as well. He stated, I can't remember what he stated right now because I don't have it, the document
Perjury,
in
wait a
front of.
minute. The short,
Yes.
perjury is a criminal charge.
Okay, there were two different charges. There was one that was intentional affliction of pain, which was not, I didn't see that as being a criminal offense, but perjury, I guess that could be considered a criminal offense.
Ma'am, I'm not going to sit here and argue about the legal definition and what's a crime and what isn't. If somebody gets charged with perjury, that is a criminal felony charge. You have to go through the prosecuting attorney and the police. So that's what you are alleging.
Yes, the document will show that, and I also sent forth the messages where he was lying, and it proved he was lying. I emailed that to the courts. I wasn't able to print it out, but they didn't say anything as far as me not being able to turn those documents in. But that should have been in the case file as well.
Did you put it in there?
I emailed it.
I don't see that mentioned in your complaint.
Address
No. If you are alleging a different count, you've got to amend your complaint to add it in. You can't. I don't know what you said you did, but you
the last time.
Complaint.
No, the last time we spoke, the last time we were in court, I never changed anything. It's just that he was not properly served, so I had to get an address for him in order for him to be properly served. That's what was the last incident that transpired, was for me to get a correct address for him.
That has nothing to do with what I asked you about.
I know you asked me about an amended.
I asked you about what your claim is about. You said intentional infliction of harm, and I assume you mean intentional infliction of emotional distress. And you said perjury. That's the basis for your claim.
Yes, I'll amend the complaint. I thought I had that already in there. I received a document, I guess after I sent the correct address and he got the document, he sent a letter that should be, I guess, in the file. He sent a letter, and
that's
then
his answer, I guess. We're treating it as his answer.
Right. And so I emailed my response to that letter, because in that letter, he lied. And then that's what brought forth the perjury. It was never perjury in the beginning. It was perjury after his response.
Well, you can't say, listen, he has the right to put whatever is in the answer.
I'm not saying he can't, but
you can't add another count because you don't like or you disagree with what is in his answer.
If he responds and his response is a lie, it's perjury, then my documents will prove that he lied in his response.
No.
And then she drops the word perjury, confidently. Except here's the problem. Perjury only applies when someone lies under oath, and he wasn't under oath. The judge explains it, clearly, but instead of absorbing the correction, she pushes back, arguing legal definitions with the judge. Courtrooms don't run on confidence, they run on procedure, and when someone confuses volume with validity, it rarely ends well.
His version. First of all, do you understand what perjury is?
Yes, I understand perjury is a lie. I know what perjury means.
Perjury is a statement, a false statement made under oath. So
exactly, and I got documents that prove he was lying.
You don't understand. It's a false statement made under oath. Under oath.
That stated a lie.
When did he testify to something that he lied about? It's a false statement made under oath.
Bottom line is, you said it's a criminal offense, so I will send it to circuit court. Are we done here?
No, you don't understand, ma'am. You don't understand.
Are we done here? Are we done here?
Perjury is
perjury
is a false statement made under oath.
I know what perjury means. Are we done here?
No, you don't.
Is it a criminal offense or not?
What statement? I don't see anything in the complaint that says he made some false statement under oath.
Because you don't know what happened. You're on the outside looking in. You don't know
But you're the
anything
plaintiff.
put on
You
that
have, wait a
document.
minute, you are the
Are we
plaintiff.
done here?
You have to
Are we
lay
done
out
here?
your
Are we done
allegations
here?
properly.
Are we done here?
No,
I
we're
know
not.
exactly what perjury means.
No, we're
Do not
not.
insult my intelligence.
You have to
Please
lay,
do not insult my
you have
intelligence.
to lay your, you have to lay your,
Please do
you
not
have to
insult my
lay
intelligence.
your complaint out. It has, you have to allege this in the complaint. You have
Please
not.
do not insult my intelligence.
It's not about that. You don't think, I don't think you understand what perjury is. It's a
Are we
false
done
statement
here?
made on
Are we
oath.
done here? Are we done here?
I
Please
said
do not
no.
insult my intelligence.
said no.
Do not do that. Do not do that. Do not insult my intelligence as if I do not understand what the word perjury means. Do not. If it's a criminal offense, then it's a criminal offense.
Well, ma'am, it should not have been filed in district court if you want
Are we
intentional
done here?
infliction of emotional distress.
Okay, so that's a criminal offense.
Do you want, are you going to dismiss it and refile it?
No,
in
I'm
circuit?
not. No, I'm not going to dismiss it. I will file another case in circuit. But as far as I'm concerned,
You can't
no, it
have
will
two
not be
cases on the,
dismissed.
ma'am, you can't have two cases going on the same issue.
I'm not dismissing the case. If you want
Well,
to
I tell
dismiss
you
it,
what.
that's up to you. But I, as a plaintiff, am not dismissing the case.
He has to make a proper motion,
Well, that's on him.
but I can also transfer the venue to circuit.
Yes, that's what I thought, because there were other cases that should have been transferred somewhere else. So that's okay.
Okay, I'm gonna do that. Ma'am, what about his costs associated with appearing because you filed it in the wrong court?
I need to see because I was not aware, since you said perjury was not on there, I was not aware that a criminal offense for intentional infliction of emotional distress was considered a criminal offense there, that it had to be.
I didn't say that. That is not what I said.
Yes,
that is not what I said.
That is what you said.
That, no, I didn't. You
yes,
said
you
that.
did. You stated
I said that circuit.
You stated that the criminal, you stated that emotional infliction of emotional distress is a criminal offense.
At this point, you almost feel for the defendant. He didn't ghost someone and expect federal charges. He went on a date. Yet here he is defending himself in court over emotional damages. There's a big difference between hurt feelings and legal harm, and that's what this hearing slowly makes clear. The judge isn't dismissive, she's methodical, breaking it down piece by piece. Because court isn't about how strongly you feel, it's about what you can prove.
And you stated that perjury is a criminal offense, but you also stated that perjury is not on the document that I placed forth before you. So criminal offense would not.
It's not in the complaint.
On there.
It's not in the complaint.
I need you to show me. I need you to show me the document which states that intentional infliction of emotional distress is indeed and in fact a criminal offense, because that's the original offense that was placed on there.
I never said that. I never said that.
Yes, you did.
I never said that.
Yes, you did.
No, I did not. Ma'am,
yes, you did.
Listen. I'm not going to sit here and go back and forth with you. I will repeat to you what I said.
I'm not either.
I said
so that's two
that
charges.
intentional. You need to be quiet while I'm talking. You need to be quiet. Mute. Can you mute her, please?
Because perjury is a criminal offense. It has to go to circuit court.
That will not make her hear you.
Intentional infliction of emotional distress.
What I said was intentional infliction of emotional distress is something that circuit court has jurisdiction over. I never characterized that as a criminal matter. It is definitely a civil claim, but it is something that can't be done in district court. Now, that's what I said to you. You are on the mistaken belief that circuit court does not hear civil matters, because you said, well, I thought circuit court only did criminal. You are the one who are mistaken about the jurisdiction of circuit court. Because that's what you stated on the record. Unmuted.
She's been talking the entire time.
Well, I said I was muted.
Judge, excuse me, you don't understand how this works. Let me explain something to you about Zoom right quick.
Okay.
When I muted her and now I'm asking her to unmute, if she doesn't do something on her end, she's still muted. So right now she's still muted. But I have asked her to unmute. She's not looking at the device that she's holding.
Is there a website where I can get the forms I need for this to be dismissed?
Listen, sir. Let me just explain this to you. Okay? You know, there are forms on the State Court Administrative Office website. Okay? But, you know, if you don't know what you're doing, if you don't know what you're filling out, you know, you're just flopping around like a fish on a dock out of the water. And the same goes for Ms. Short, because she apparently doesn't understand the jurisdiction, what types of cases can be done in district court and what types of cases can be done in circuit. That's why we're having this issue right now. So, you know, look, how could I put it? If two people that have no military training, amateurs, and they want to throw hand grenades, well, you know, if you don't do it the right way, you might blow yourself up. You might blow the other person up, but you might blow yourself up too. If they don't understand how the process works, I would say this to both parties. You need to seek out legal counsel.
Now the structure of the case really starts falling apart. Wrong venue, missing legal elements, no evidence of intentional misconduct. You can see the judge doing something important here, educating while ruling. The defendant looks relieved. She looks frustrated. But frustration doesn't substitute for a legal foundation. You can't file a lawsuit like it's a complaint form and hope something sticks.
I can barely hear what you're saying. Like I said, I'm at the airport. There's a lot of people around.
Ma'am, are you getting ready to go on a trip or something?
No, I actually just came. I had a rental car.
Oh, I see. Ma'am, this is what I'm doing. I am ordering that this go to 7th Circuit Court. Venue is to be changed because intentional infliction of emotional distress is a circuit court matter outside the jurisdiction of district court. Plaintiff shall pay the filing fees in the receiving court. I don't know if you asked for a jury trial or not. You did not, it looks like. So there was no jury fee. No further proceedings shall be had after transfer until these costs or expenses are paid. If not paid within 56 days of the date of this order, this case shall be dismissed by the court to which it was transferred.
And what cost am I paying? Hold on. What cost am I paying for?
The filing fees for circuit court.
Why am I paying for filing fees for the circuit court? Because there's been multiple cases that have been brought forth.
Because you filed it in district court, we don't do intentional infliction of emotional distress cases.
Well, I need to see that in writing. I need to see that document in writing that states that
if you want to appeal, if you want to,
I've already skimmed SCAO. I've already skimmed that. I'm reading constantly every day, and I did not see that form on there.
I'm sure that you are. But
yes, I am.
If you want to appeal my ruling, you got 21 days to do it.
Yep, I do.
You got 21 days to appeal it to the circuit court. My ruling. Thank you both.
And just like that, it's over. No dramatic victory speech, no massive payout, just a calm judicial dismissal. The judge handled it professionally, without mocking, without escalating, just facts. And that's the lesson here. The legal system requires standards, evidence, intent, actual damages, not just disappointment. So tell me, was the judge too patient, or exactly as composed as she needed to be? Drop your thoughts below. And if you enjoy courtroom breakdowns that mix law with real-world perspective, like and subscribe. I'll see you tomorrow.